Welcome to another episode of Conduct Detrimental. Dan, and the NFL. Dan, how's it going, my friend?
It's going well, Dan. I remember having Deshaun Watson fatigue a couple of weeks ago. I may have made a couple of statements during our podcast that why are we still covering Deshaun Watson? This was like a month ago, 2 months ago. I've seen the light, Dan. I found religion. I'm all in on Deshaun Watson all the time. This is becoming, I guess, the 2022 version of Deflategate, almost on the same trajectory without, obviously, different issues. But man, was I wrong, because until you actually get to a hearing and begin holding things up to the light and looking at them very closely, it's just a different animal when you're in the hearing and all this stuff starts coming out. Whereas a couple of months ago, it just seemed like we were just repeating some of the same topics. This has been a great story to cover, and it's only just beginning.
Yeah, I was going to say, well, we're going to get to the Deshaun Watson stuff on this episode. We have Charles Robinson joining us, senior writer over at Yahoo. He has been on with us before.
He's
so
good.
We're going to talk. He is very good. We obviously recorded with him already. You guys are going to hear it. It's a real treat. We had him for 50 minutes. So sit back. I think it's Dan and I were talking. I think it's our second longest interview we've ever done. Our longest one before that was Howard Balzer with the St. Louis Rams saga. So Charles is great. We got into the weeds. And if you're listening to this podcast, we've covered Watson a lot, but there are a lot of nuances and there's always new stuff to cover with us. So Dan, you talk about seeing light with Deshaun Watson. On a personal note, I saw the light a little bit this weekend. My 34th birthday on Friday. My daughter turned 1 on Saturday. So,
happy birthday to both of you. Big party in the Lust household over the weekend.
It was. We had it was a big party right outside the Lust household. We had a bounce house. We had Ben and Jerry's ice cream stand. It was a good weekend. I put on like 5 pounds in ice cream, but it was a good time. The over under is 5.5.
Happy birthday to both of you, and it's really cool to be able to share a birthday with your daughter.
It is, but then again, I no longer have a birthday, so it is what it is. One other housekeeping note, and then we'll jump into the fun stuff. We're going to cover Snyder and Watson today. An announcement from my law school, where I teach at New York Law School. We launched one of the first program of its type in the country, the New York Law School Pro Bono NIL project. We're not quite a clinic, but we're offering up our services to high school and college athletes who are looking for. I was going to say affordable representation, but this is free representation to the extent that we can't represent certain athletes because they are outside of our jurisdictional window and because there's a state NIL law. The blessing of doing this podcast, and we know NIL lawyers in every state, so we can hook you up with someone. So if you're listening to this, you know of someone that needs some help, some affordable help or some free help, if we can represent you. Certainly you can hit us up, and you know where to find us on social. I will say one more thing, Dan. How about this? We are debating doing some an advertising with a law firm. And a lot of you guys listening to this are lawyers. You're at small firms. To the extent you want us to advertise your practice, we're not opposed to it. We just have our friends at Themis here. We have some other sponsors that are, in the works, in the backgrounds. We obviously do some stuff with Quimby. But, if you want to get your practice out there, your NIL practice, how about that? You can reach out to us. Dan, I think that's a good time to jump into our topic. So we have Charles to talk all things Deshaun Watson. The other NFL topic that we want to discuss this week, we're going to discuss, I think, the Miles Bridges stuff later in the week, the Casey Close stuff, the Henry Ruggs stuff, a couple updates. But we wanted to spend this episode talking about Deshaun Watson and, Dan, one of your favorite topics, Dan Snyder. So
and Dan Snyder's yacht.
And Dan Snyder's yacht. You want to give everybody the latest? I don't think we've talked about the date that's been put on the calendar.
Well, I think this was a little bit of a stare down between the House Oversight Committee and Dan Snyder's lawyers. A week or two back, Dan Snyder indicated a willingness to appear before the House Oversight Committee on July 28th. The only catch is it's now July, I guess the day that we're recording this, it's July 20th, and 8 days out from the hearing, we don't have any firm commitment for the hearing because he doesn't want to be subject to a subpoena. He wants to appear voluntarily because once you're under the subpoena power, then there's a sort of process and he's going to be compelled to answer far more than I think he wants to volunteer. So at this stage, I would be surprised if we're doing another conduct cast on July 28th, where we're watching and commenting on Dan Snyder's congressional testimony in real time. I think this is the biggest stall game going on. And if he had wanted to appear, he would have made a commitment. He wouldn't have dodged the hearing. He wouldn't have gone on his boat to Cannes. He would have appeared virtually just like Roger Goodell did. So I think this is just, more of the same of yanking the House Oversight Committee's chains to run out the clock. And now we're almost into August. The elections are in November. And I am very skeptical that Dan Snyder, who will collapse and fold or plead the fifth, he is not going to yield anything. And if he does talk, it's going to go very poorly for him. And I think he knows that. His lawyer knows that. And I just don't see him testifying. And I hope I'm wrong, but I'm not going to get too excited about July 28th because there's just a lot of back and forth between Congress and Snyder's attorney, and he just doesn't want to testify. I think running away to France is proof positive of that.
And Israel, Dan, don't forget that he was in Israel. He claimed a religious reason that he was observing the anniversary of his mother's passing. So Israel, France, the yacht goes everywhere. He's like the modern day Carmen Sandiego. Dan, part of this, there's a song and dance going on and a back and forth with Snyder's attorney and the House Oversight Committee. You guys don't need to subpoena him because he's appearing voluntarily. So, then this leaves open potentially, right, that he could be called to testify again under subpoena power, right? There's this weird loop here, Dan, where he could testify voluntarily from his yacht. Obviously, that seat's going to be a lot colder than the one that would be in person. But Roger Goodell testified via Zoom. Dan Snyder could do it. Yes, you could be in Israel observing the anniversary of the passing of your mother, but I don't know. Couldn't you still just pop back to your yacht and pop on the Zoom? We're missing something here, right?
Well, they're playing game. I think there's so much gamesmanship going on that Congress should just issue a subpoena. The problem is he's nowhere to serve because he's sort of on the high seas in the Mediterranean. His lawyer won't accept service of process for the subpoena. So short of voluntary cooperation, they have no way to use compulsory legal process to haul him into Congress. So maybe the House Oversight Committee should shift its focus a little bit and try to get these documents rather than go through this lost cause of trying to pull Dan Snyder in for testimony. Why not try to go after some of these so-called privileged investigative materials, subpoena the documents custodian, and let's test the applicability of the attorney-client privilege in a congressional proceeding, because it's really about trying to get the written report. The NFL has held it back, has not authorized one to be written, but the investigative materials will yield a lot of information about what went on behind the scenes and what information and witness cooperation was made available to the attorney overseeing the investigation. So I would direct my subpoena to other parties, put some pressure on the league, maybe to put some pressure on Snyder to come in voluntarily and stop his gamesmanship. Because without that pressure, Snyder's going to continue to engage in this dilatory behavior in the hope that the calendar runs from July, August, September, October, and then he's run out the clock if the Republicans take control of Congress.
So I'm going to just, while we're here for a second, I mean, this is the interesting part that people are, and Dan, I want to give you your, just like taking us back in time. Dan, you had at one point had mentioned that Dan Snyder might be able to take this thing to court and fight it on the front that Congress doesn't have a legitimate purpose. Look no further than the Goodell hearing, where they were all over the place. They weren't really pursuing, workplace, toxic workplace. Certainly that there's an argument there that Congress kind of got off the rails. But just by the nature of the fact that Snyder is agreeing to appear via Zoom or remote, whatever you want to call it, he might not give you anything of substance. And it might lead to Congress wanting to call him back. So Snyder's still got plenty of bullets to fire, is my point here. Just by nature of the fact that he's showing up, virtually doesn't end the saga, because he could show up, plead the fifth on everything, and that might not be enough for Congress.
Well, it might be preferable. You raise a good point that Dan Snyder could have some viable legal arguments if and when he's actually subpoenaed. You can't file a lawsuit without there being a subpoena issued to him. So maybe the House Oversight Committee is making this choice that it's better to have him come in voluntarily than to risk having this be delayed by litigation, because once a subpoena is issued, Snyder's going to challenge it in court. And just like with some of the impeachment witnesses, there's not going to be a court ruling before Election Day. So maybe the preference is to have something instead of nothing, because a subpoena will undoubtedly be challenged. He might have bona fide, meritorious arguments that Congress's inquiry goes beyond the scope of its legislative purpose, and that in any event, a lot of the materials and information that they would be seeking from him are covered under a joint defense privilege with the National Football League. So if they go down that route with a subpoena, they're going to be facing A, a lawsuit, and B, the possibility that a court will derail this congressional inquiry. So maybe getting voluntary cooperation, even as diluted as it seems to be, is better than running the risk of losing, because even in this narrow voluntary type of cooperation, they can ask Dan Snyder a lot of questions that if he's going to keep denying or pleading the fifth, it's going to make him look even worse. So I think maybe the House Oversight Committee has made a choice here as to the route they prefer to take because of the legal vulnerability associated with the subpoena and then an ensuing court battle, because they could have subpoenaed him months ago and the NFL months ago, and they never did that.
I want to stick on this one before we move over to Watson. You raised a point that I have not seen anyone raise, and I think it's worth exploring. There is an attorney that's associated with the Washington Commanders, their battle over the minority partners, right? At one point, the minority owners were in a legal battle with Dan Snyder for control of the team. They wanted to sell their shares, but Dan had a buyback provision. Now, in the course of that dispute, a text message came out from John Moog, a lawyer who's had some involvement with Snyder back and forth. And one of those texts was Moog sending something to Snyder, and it was alleged that Moog was threatening him. But Moog has a reference to, and I'm paraphrasing, but people might find out about the more serious shit. There seem to be people around the organization that are aware of, quote, there's more serious allegations. So we can't get to Dan Snyder. And obviously Dan Snyder's made his fair share of enemies over the course of his tenure as owner. Maybe that's the next step for Congress. But to your point, Dan, right, you got to worry about the shot clock here. If you keep waiting month after month in these midterm elections, all of a sudden the Republicans take over. I don't think a Republican-controlled Congress is going to care about Snyder. I think they're going to let him off the hook. And I think that's going to be the end of this investigation. I mean, isn't that your read on it too?
Well, that's been pretty evident from some of the statements made during the committee hearing a couple of weeks ago. There was antagonism and disinterest from the members of the Republican, the Republican House members who spoke and asked questions at the hearing. They made speeches decrying this investigation and moreover pointing to all the other ills that the Democrats are not addressing. The opioids, this and that. I mean, it became a soapbox for Republicans to, basically use their time not to address the merits of any of this, but just to do political grandstanding. So we know exactly what's going to happen if the balance of power swings back in favor of the Republicans, which underscores, that time is of the essence here. It's 3 months and a few days until Election Day. What is the House Oversight Committee? What are the House Democrats waiting for? They had ample opportunity to subpoena Dan Snyder way early in the process. The fact that we're now in late July and he's sailing around the world beyond the subpoena power of Congress, I think speaks to Congress's inaction and this House Oversight Committee's indecision about how to proceed. This hearing and investigative process should have been underway and expedited much sooner in the calendar year, because now Dan Snyder's strategy is fairly obvious. Duck, dodge, delay, and sail the high seas in the Mediterranean.
Dan, as they say, if you can dodge a wrench, you can dodge a ball. You know what that's from?
Yeah, of course.
What
it's
is
dodgeball.
Okay.
Dodgeball. In fact, whenever I say dodge, duck, the word duck connotes dodgeball. So that's the lay of the land here. A lot of this is just seemingly a waste of time, because we know that Dan Snyder is not going to appear voluntarily, and if and when he does, he's not going to answer anything substantively. So I would have taken a different approach if I was in the role of the chair of the House Oversight Committee. I would have placed pressure right away on the NFL rather than draw this out, because it's already been almost a year. Well, not a full year, but it's like on the 9th or 10th month of this investigation, and they've only had one NFL-related witness, which is, just an embarrassment given the gravity of what they're investigating, to let the NFL off the hook like this, and to pass on the opportunity to haul Dan Snyder in much earlier in the process, I think speaks to the inefficiency of this committee. They should have been issuing subpoenas a long time ago.
Well, we will obviously keep tabs on that, Dan. I think maybe a conduct cast part 2 is in the works, but certainly stay tuned. Okay, so that'll bring us to our main coverage today. Again, we don't intend to keep covering Deshaun Watson. We'll keep having new developments, new twists and turns. Before we get to Charles Robinson, a reminder: our podcast is sponsored by Themis Bar Review, top bar prep company in the galaxy. Dan, you're going to call me crazy. I might be taking another bar exam. I'm thinking about it. I don't know which state, but that UBA is looking pretty tasty. And if I'm going to help out on the NIL front, then I'm going to have a couple more states under my belt. So I'm thinking about it. Do you think that's insane?
It's just a test. We make a lot. We make a big deal about it. But the more distance there is between law school and taking a bar exam, the more daunting it seems. I mean, I had to take a bar exam in Florida 10 years after I graduated. It was difficult, much more difficult when you're away from the, sort of taking your classes and being in the mindset of being a student. So you'll pass. It's just a big time commitment to study for it.
Well, if I do it, I'm going to be using Themis, which will make it that much easier. So it's not just a ruse. I'm actually thinking of doing it. It's a matter of which state. My firm is based in New York. We got some office. Firm is based in California. We also have an office in New York. So California bar would help, but Dan, maybe a bar in your neck of the woods over in Florida. But you can't wave into those states. I'm 9 years out of school. You can't wave into Florida. You can't wave into California. So pain in the you know what, Dan. So is what it is.
Well, those are NIL states. If you're going to pick a second state, you're going to pick California. Is going to be a real hard, tough sledding to pass that, because the differences between New York and California, there are a lot of distinctions. New York and Florida is a little bit more compatible. So as a New York trained lawyer, you're going to be able to get over the hurdle in Florida much more easily than you can in California. So good luck. I wouldn't do both at the same time. That much is for sure.
Yeah, not both. I pro hoc in on a couple cases in California just because my firm needs the help there. So we'll see. But again, if I'm going to do it, I'm not just saying it. Themis is the best, so I am going to use them. Okay, Dan. Charles Robinson, we have a lot of updates. We all joked offline before we hit record. There's all these Twitter pundits that are going, oh, it's going to be between 0 and 4 games, between 4 and 6, between 8 and 10. It's going to be a year. It's going to be 2 years. So we've hit the whole gambit. So, Dan, I think it's safe to say that our sources at Conduct Detrimental, which are undefeated, are saying between 0 and infinity games. I think that's a safe prediction. Charles obviously is a great source. If Charles tweets it out, I would believe it. Charles was been on our show talking to Deshaun Watson in the past. He's usually pretty good. He was, I think one of the first on the scent that there was a potential deal in the works to send Deshaun Watson to the Miami Dolphins way back when. And people got in his replies and yelled at him. Turned out he was right. And again, he's the one here saying that he's hearing on good authority that if Deshaun Watson is suspended for 1 year, that they will take the case to federal court. Charles Robinson is in the know. I would be paying attention to his feed early and often. Dan, anything to add before we kick it over to our discussion with Charles?
Yeah, I would love to see this end up in federal court, but I think Deflategate stands as a barrier to any attempt to overturn a suspension or an increased suspension levied by Roger Goodell if he were to review the discipline rendered by Judge Robinson. So I'm really interested to see this decision, how Roger Goodell might deviate from it, but we're a long way away from Deflategate Part 2. But let's bring Charles on and we'll go down this road with him. There's a lot to talk about. Watson is now beginning to heat up and we're going to have a decision any day.
Okay, Charles Robinson on social media at Charles Robinson, senior NFL reporter for Yahoo. And with that said, we will kick it over to Charles Robinson.
Charles, welcome to Conduct Detrimental, or should I say welcome back? How are you, my friend?
Doing well. How you guys doing today?
We are good. So listen, we got the two Dans. We got Charles. Charles, I think you said in a previous life you wish you had gone to law school. So for Purposes of today, we're going to give your honorary JD. We're going to dig deep into this Deshaun Watson saga, which Dan and I have been circling for the last weeks.
I'll tell you what, I wish any of my law school classes had something as threadbare as a 6-page Article 46, an 8-page personal conduct policy. That's basically one lecture in an entire course on contract law. So if they're going to give an honorary law degree for that, they're giving them away pretty carefree. Which brings us back to the main point. These are very important documents. And now that we finally have a real proceeding with a lot of intrigue around it, we are parsing every single word of the personal conduct policy, the CBA, Article 46, Deflategate, and so on. So, Charles, you're an insider who's really had a couple of revealing tweets and comments over the past few days. Do you think this is headed to a federal court battle, as you've been told?
I do 100% believe that is the decision that's been made, but it hinders on what ultimately Sue Robinson decides. Like, if she comes out and says, hey, I'm leaning into what the NFL believes should have been the standard here in terms of suspension. I think it's a year. I don't think there's any way, shape, or form Watson's camp or the union is going to stand down at that point and just move on. Particularly, I mean, look, first and foremost, as we've seen in the past with Ezekiel Elliott, Tom Brady, the union's going to do its job, and its job is to try to protect the earning ability of a player and also protect precedent, and that's what they're going to do.
Okay, well, your tweet the other day, or maybe it was yesterday, said that the NFLPA and Watson's camp are going to file a federal court lawsuit if the suspension is 1 year or longer. And there's another intermediate step here. The path from Sue Robinson to federal court has a stop at Roger Goodell Drive.
Right.
So, what do you think the messaging over the federal court lawsuit is a shot across the bow to Roger Goodell, that if he somehow takes this modest amount of discipline that, let's say, Sue Robinson imposes, and then reimposes or meets out the same discipline that the NFL recommended, is this designed as a message to Roger Goodell that if you do that, we're going to call you on the carpet and file a lawsuit in the Southern District of New York or in the District of Delaware, because now you're going to run the risk of setting different precedent than Deflategate. So what's the psychology behind, these leaks and these revelations regarding the next steps?
Well, I can promise you that it was not designed for effect based on the reaction I got after I put the information out there. I don't think anyone was pleased that I let it be known that this is effectively where the process is at behind the scenes. And I think part of the reason why the parties involved were not happy about it was because the last thing they want is anyone to think they're trying to influence Sue Robinson at this point, particularly when the parties involved felt like after the hearing with Sue Robinson, they walked out with a winning hand. They felt good about how they presented. They felt like the NFL presented a weak case, and they thought, let's just sit back and let it do what it's going to do. We think we're in a good spot here. That doesn't stop me from reporting what I have to report when I have information, particularly when it's sourced from multiple parties. And, so I can just tell you, it certainly was not a leaked for effect piece of information. But I also will say this, I was slightly surprised that people were really stunned by this piece of information, because past history, even with the change in the CBA, even with an arbitrator being put into place, suggests that Jeffrey Kessler being involved, the union being involved, and players taking these things to the places they've taken them before are not going to sit there for what would be a historic suspension, and particularly under the given circumstances of not presenting 24 women before Sue Robinson in the arbitration hearing, presenting 4, really 5, but one of which did not speak with the NFL. I don't think there was any chance that he wasn't going to go to court if either Sue Robinson or Roger Goodell held up the 1-year suspension. And frankly, I knew this. I will tell you, when I first knew this, it was when the league said we want a year, and they tried to meet out some sort of an agreement before going to Sue Robinson. They tried to reach some sort of settlement, and they were so significantly apart on that, and it fell apart so badly, and it went to Sue Robinson, that was when it was dug. I mean, it was dug in at that point because I think Watson and his camp, the union, everyone involved on that side of the fence knew they're not backing off of this. And then they watched the league put that piece of information out there that they wanted the year, that they were going to earn sort of the optics end of it by saying, hey, here's what we want. Everybody knows what we want. So if it goes another way, there's no illusions about where we're standing on this and what we're reaching for in this position. So this wasn't something that just developed over the last week. It was something that started when the negotiations for a settlement fell apart before they even met with Robinson.
So what's interesting is that people are taking your tweet as saying, and people can read into it as they want, but hey, this is a leak because they think that they're actually going to get a year and they're trying to scare Sue Robinson.
That's right? 100% incorrect. I will even address that. As a matter of fact, I think that it is the opposite of how those involved feel. I will repeat, I think coming out of the hearing, the reason why you've seen so many reports of maybe it'll be 8 games, maybe it'll be 6, maybe it'll be 0 games. Everyone's, throwing, but you have not heard a lot of it's going to be a year, right? And we've heard the opposite. It's going to be far less than what anyone expects. And then that's going to set up the scenario about what will the league do? How is this going to progress forward? Well, the reason why you've heard all these numbers that were smaller than anyone expected was because of how the hearing went. Because the idea when this all started was that the league was going to go before Sue Robinson, was going to present 10, 12, 15, maybe 20 of these women who had filed civil suits against Deshaun Watson. The problem is 20 settled, okay? And not only among that 20, that was damaging for the league's, ability to present before Sue Robinson, just in terms of sheer number, but also because the only women who actually accused him of physical violence, of force, they were among the group that settled. So they were no longer going to be presented. And then all of a sudden you hear, well, it's 5 women, but then it's 5 and actually 4 because one hadn't spoken to the league. It just became this pared down number. And then they started to argue. And then, we've since heard about the briefs where it was very focused on the league saying, for lack of a better term here, this idea of disrepute, Deshaun Watson bringing disrepute upon the league, and this sort of nebulous idea of how he violated the personal conduct policy versus what Jeffrey Kessler, the union, they're standing there saying, okay, well, if you want to talk about disrepute, let's talk about whether or not there's similar actions being taken with NFL owners, because we can sit here and roll out all kinds of scenarios involving disrepute with the owners that were never even investigated. Is this the standard now that you want to set given this case? And oh, by the way, here's the exact language of your personal conduct policy. Here's what you said about owners being held to a higher standard. These are your words, not ours. I could see why when this all unfolded and it came out that maybe the league did not necessarily feel like it presented the case that it thought it might be able to 3 months ago or 6 months ago.
While we're trying to figure this out, and there's a lot of people not only guessing the amount of the suspension and, people are saying 0, it could be a year, whatever it is. I don't think we can read anything into that at this point. But people are trying to say that the Browns camp is scheduled for July 27th. And I know beat writers across the country, all different football writers are going to these camps. They're trying to set up these one-day trips. The news, right, kind of, revolves around when camp is starting. So people are like, oh, they've always said they're going to get a decision before the summer.
Right.
That was the NFL's expectation. But I don't know. I think we should kind of address the elephant in the room, right? Judge Robinson is an impartial judge. She gets to make the call here. There is nothing in the NFL CBA or the personal conduct policy that requires a decision by a certain date, by 1 week, by 2 weeks, by 30 days. We have no concept of that. So, Charles, I have not heard anything concrete as to when we're going to get a decision. And I think that's probably accurate, right? I don't think there is a date. It could be as long as it needs to be.
Okay. And early on in this process, I think I'd used the terminology, well, they expect to have this or they expect to have that. But I will reveal this, I guess. As the process has gone along and the more you talk to individuals, particularly as it bumped up right against the hearing and then right after, I started to recognize that I need to change that word to hope. Like maybe they say they expect it, but in reality, the language that they're using conveys a sense of, well, we hope we get it in, July 19th. We hope we get it maybe the Monday following. We hope we get it a week before camp. It's clear that all along it's been a hope. There's no mandate involved here. And people could think whatever they want about what Sue Robinson might be doing, but literally this is what she was retained for. Okay, this is what this entire independent arbitrator setup was established for by the union and by the NFL, to lend some legitimacy to a process that before looked like a kangaroo court situation. Okay, so the longer she goes and the less she's on the league's timeline, the less she's on a union timeline or anyone else's timeline, is suggestive of the position working the way it's supposed to work. She can be thorough. She could do everything. Like when I expect, and I think I saw you, Daniel, say this, or Dan, it might have been you, or both of you. I expect that when her judgment is rendered, there's going to be a very detailed offering to both the union, to Deshaun Watson, and to the NFL, showcasing, here is how I arrived at this. You know, this is the work that I did. And frankly, I think that fundamentally, if one side or the other decides to appeal, which I think an appeal would be more damaging to the credibility of the league than it would Watson and the union. They have nothing to lose here. They should and could appeal anything they want, because again, they have nothing to lose, particularly if there is a number of games suspended. If she is very detailed in her judgment, for Roger Goodell or the NFL to decide we're going now appeal this, effectively is saying to her, all of this work that you did, the basis that you used to come to this judgment, we're rendering it moot. We're rendering it either moot, or we're just flat out saying you're wrong. Like
It's almost like it didn't happen. Right.
It's almost like it didn't happen, which is, I cannot imagine like if you're the league, and let's say when she comes out, who knows, 40 pages, 50 pages, 60, who knows how long this will be. Are you going to sit there and look at that and go, we're just going to say this is all BS? We're just going to, that's what we're going to say here. We don't agree with it. So we're going to go ahead and invalidate all of it.
Well, Charles, I don't think it would be invalidating Judge Robinson's decision on the merits. If she finds that there was no violation, that's it. Case over.
That's it.
Everybody goes home.
Yeah, that's the end of it. I mean,
If there was a violation, then it becomes an appeal on what's the appropriate amount of discipline. And the players gave that away to Roger Goodell in Article 46, that he doesn't even have to respect her ruling just based on the evidentiary record. His view of the evidentiary record, he can upwardly modify the discipline even if she believes a lesser amount is warranted. And I go back to the fundamental question: if the NFL wanted to lend an air of legitimacy to having this respected federal court judge, who is the chief judge of the District of Delaware in the U.S. District Court, why would they have the apparatus of preserving Roger Goodell's ability to fundamentally disagree with her on what's appropriate discipline? It renders her level of fact-finding essentially, if not moot, I wouldn't say it's moot, but would seem like a big waste of time. And the perception, from the Players Association, and even the public, would be that the NFL is simply going after its pound of flesh, and they're going to impose the discipline that they felt was warranted in the first place,
yes,
which could create problems under the Deflategate ruling.
And I think that is the optics question that comes into play here for the league, is if we strike this down, if we appeal this and we decide that, to effectively say, okay, well, she agrees with us that there was a personal conduct violation, we just disagree on the number of games he should be suspended, you're threading a needle there, because once again, it looks like unilateral justice. Okay. Really, the only thing you gave away was the ability for an arbitrator to decide whether or not a violation occurred. And I think most arbitrators would act in good faith. And if there was a violation there, a violation occurred. And then it would, to me, if you're the union, you're sitting there and you're saying, this effectively speaks to us that what the real process is. The arbitrator decides whether or not a violation occurs, and then the league decides what the suspension is. Like, that's, the arbitrator never decides. The reality is the arbitrator never decides the suspension. It's the NFL either deciding it unilaterally or rubber stamping what it agrees the suspension is.
Well,
that's really what the process is.
Charles, this brings us back to the Deflategate decision from the Second Circuit U.S. Court of Appeals. What your sources on the player side have yet to address is, how do they expect to thread that needle with respect to Deflategate, which basically the only inquiry for a federal judge is, was the arbitrator acting within the scope of his authority as defined by the collective bargaining agreement? And the Players Association ceded to Roger Goodell the authority to not only hear appeals, but to modify the discipline. And you touched upon imposing your own brand of industrial justice, which is another sentence in Deflategate, where if that condition exists, that's one basis on which a federal court can vacate a labor arbitration award. Does Jeffrey Kessler want another crack at Deflategate with this case?
I can't speak to how they're going to build that bridge. Okay. And I understand the question. And frankly, up until now, it's been an unanswerable question, because I don't think they've thought that plan out far enough. And another thing too, the reality is, for them to be able to create a winning scenario, they have to find somewhere in the process where the NFL didn't follow its own rules, made some kind of mistake. I mean, it's not even about right or wrong. That's the thing that people always forget about Brady and Ezekiel Elliott. It never came down to right or wrong. It was just, did the arbitrator act according to the rules that were agreed upon by the two sides? And if they did, this is over. It's going to be the same in the Watson case if this ultimately gets advanced. Now, that said, there's a lot of lawyers involved in this. They get paid well. They can be creative at times. And frankly, there were even times during, the Ezekiel Elliott case, although, obviously that began in Texas, so it's not apples to apples. But even in the Brady situation, I was surprised it advanced ultimately to the 3-judge panel that it ultimately did. So I don't know if someone, whether Jeffrey Kessler can pull a rabbit out of his hat, whether he's had enough cracks at this that finally, he figures out what the Achilles heel is. I'd be fascinated to know, but up until now, and considering the precedent set by Deflategate, it's hard to believe that.
Yeah, Charles, it's so hypothetical and speculative at this juncture. We don't have a ruling from Judge Robinson, and we don't know how Commissioner Goodell is going to treat it. So we're simply chasing our own tails at this point to try to construct a winning argument. But the Deflategate case occurred late in the summer. The federal court lawsuit was filed in early August, and it wrapped up, at least on the district court level, in time for Brady to suit up for week 1 of the 2015 NFL season. What role, if any, does the timing of the NFL regular season play into Judge Robinson's time frame for a decision? Because understanding the levels of attack that are about to come afterwards, an appeal to the commissioner, a federal court lawsuit, do you think there's some sense that she's working to meet that deadline in the sense of leaving the parties enough room to take it up on appeal and have finality before week 1?
I can't speak to her mindset, honestly. I mean, it would be complete, pure, absolute speculation for me to try to get inside her head and figure out why she would want to be on a certain timeline or not. In my mind, no, she shouldn't care about the NFL season. It doesn't, regardless of whether there's an NFL season that's going to begin or not, regardless of whether or not there needs to be times for, expedited appeals or, further legal processes to take place, and by the way, an appeal, if her decision is appealed as well. I don't know that I've seen anything, any documentation or any agreement whatsoever between the union or any establishment of this position that says, hey, we expect you to get this done in a certain time frame, especially if we got a season coming up.
It's Article 46, the time frame that's imposed on the disciplinary officer is to issue a decision as soon as practicable.
As soon as practicable, though. But
that doesn't mean
that's pretty vague. That's pretty vague.
If I'm a federal judge with 300 cases, as soon as practicable in the normal world,
she has one.
I know that's the point. That's the point. Normally, it's 1 month to 2 months for a ruling on a motion in federal court on a standard motion. Post-trial brief, maybe a little longer. Here, she has tunnel vision. This is her only case, presumably.
Well, if she's not involved, I mean, obviously she could be involved in other, obviously non-league things. I mean, we don't know if there's other things she's involved in. But see, here's the thing. I understand where you're coming from, but where is that established? Like, it's that is a theory that, hey, you only have one case. There's no doctrine that says that, right? There's no doctrine that says, we're talking about the Watson case here, right? And all these depositions happen, and all of a sudden there's leaking of depositions, and there's leaking of videos and all this stuff. And I'm like, hey, wait a minute. I'm talking to the lawyers involved. I'm like, well, you're not supposed to do that, but there's nothing barring us from doing it because it's not under protective order. Okay, well, I mean, that's kind of a similar situation in terms of just there's no language that dictates. The league can't all of a sudden come out and say, you need to give us this based on this timeline because this is how we define this term in the document. I mean, really? Like,
So
how is that?
let's Yeah, well, I want to stick on this point for a second because we should address the one element of the story. Obviously, within this past 2 weeks, Baker Mayfield traded, which I don't really think has any relevance to this. But what I do think does have some relevance, we're talking about theories and why delay might be occurring, why it might not be occurring. In the middle of all this, the Texans reportedly settled 30 different cases. There was only one active lawsuit. So that tells you that 29 other cases, the way it was phrased, were that could be, that are filed or that would be filed. So if people listening to this and they need to keep track, right? There were 24 active cases. There were, I think, one additional case that had been filed but withdrawn because she didn't want to reveal her name. So that leaves an additional 5 cases that have just been unaccounted for. So Tony Busby, who is part of the leaks, either one way or the other, has said in the past that at least 2 more cases are going to follow. So now he looks like 5 more cases might be in the works. So while this delay or this point from the end of the hearings until the point of the decision, we have all of these Texans cases settled. Charles, I'll throw out a random theory for you, right? If Tony Busby is willing to settle those 30 cases for some amount of money that we don't know what it is it possible that the parties, those 4 remaining cases, are trying to work out a settlement here? Because from my standpoint, right, this is really the last piece of leverage they have, that, hey, we would be willing to settle the case. Maybe, maybe not. That's going to impact the discipline that's issued. Maybe from the league's perspective, they'll go that much easier if all the cases are settled. Just throwing out a couple things here. Are you hearing anything on that front?
I don't know that even a settlement now would change the trajectory of what's going on. I think if those women settle at this point, it bears no relevance on the NFL's case moving forward. They already have the information they have the interviews. And I don't know how all of a sudden that would be invalidated by a settlement amongst that particular 4. And here's the thing about that 4, and the reason why I don't expect that to happen.
Which 4? The 4 that are talking to the NFL now, or the 4 remaining active cases? Because I don't know if we've ever heard if those are the same 4.
The 4 remaining active cases.
Okay.
Which I don't know if it's a perfect overlap with the 4 that were presented. I know there are common women between the 2. I don't know if it's a 4-for-4 match, though. However, I don't believe it is a perfect 4-for-4 match.
I think we would have heard that.
Said,
I haven't seen it if it is.
Yeah. Now that said, the 4 individuals that are still, processing obviously through the court system, they've had their opportunity to settle. They were, from what I understood, when it was 22, that 4 was included in the 22. And that was actually when settlement talks first came down the pipeline during the course of the season, and Deshaun Watson tried to reach a settlement agreement in which, he tried to get a global settlement with all 22. Initially, 20 agreed, and then 2 of that 20 also backed away, and it became 18 of 22. That held up a settlement all along. And from what I understand, those 4 that held out then are the ones that continue to say, I want my day in court. I'm not interested in a settlement. And that's why 24 became 20. But I think those 4 have been pretty well entrenched in where they're standing here and the fact that they want to move this, forward in a courtroom. So
I'm going to give you one more while you're on our witness stand here. You're sworn. We forgot to read you your oath here, but you're sworn.
I assumed it.
Yeah. So I don't know the answer to this question, but and usually when you're like taking a cross exam or you're doing a direct exam, you kind of always need to know where it's going. You don't want to get in a lot of trouble here, but like, I'm curious, right? 20 out of 24 cases settle. You and I are of the same opinion that like those 4 remaining cases are maybe the same 4 that are speaking to the NFL right now. Maybe there's some overlap. Maybe it's 3 out of 4, 2 out of 4. Now, I have not heard anybody explain this, but those 20 women that settled their cases, right? And the 6 additional women that have sued or that are involved in the Texans lawsuits, why are only 4 women at issue in front of the NFL? Like, who made up that number, right? Where did that come from? You have 30 potential violations of the personal conduct policy, yet only 4 are speaking to the NFL. So people are wondering, oh, well, could it be 2? Could it be 8? People need to keep in mind, like, we're not talking about all 30 women. The NFL is only looking at 4. So whatever people thought, right, that maybe you could get to a year because you have 30 accusers. I don't know. That math doesn't necessarily work out.
So here's what was explained to me was that it actually wasn't just these 4 who spoke to the NFL. So it was more than 4 women spoke to the NFL. However, when the NFL decided to present, it was tailored down to what they thought was essentially the most presentable group possible. They're like, what gives us our opportunity to move forward, illustrate our case to Sue Robinson, illustrate what we believe where the merits are here. And there was no, could they have included other women in it? Yes. Was the evidence that they would have presented as strong as the 4, as strong? Again, based on however they viewed the evidence and the strength that it carried, or how they wanted to present, those 4 fit. Okay. And actually it was 5. The 5th one, the information was largely from media reports. It was not from direct interviews with NFL investigators. But again, that's what I was told, that they decided to focus down on a smaller group rather than bring a broader group that would have featured some that would not have been as effective as, I guess they felt like, look, the point is illustrated by the group that we're bringing forward. There's overlap amongst all of them. There's contemporaneous evidence. There's, digital evidence, whatever we can present. This 4 gives us our solid standing.
Charles, I just have a couple more before we let you go. When you talk about going from 25 plaintiffs to 12 who approached the NFL to 4 or 5 being presentable, some of this sounds like a euphemism for a number of them may not have been very credible, and the NFL not necessarily going with its, just the best 4, but that the other 8 may not have been enough. Why would the NFL ever leave a good case, sort of on the side if they could present it? I want to go back earlier to something you said, which is the most revealing thing that I've heard come out of the hearing, that the perception is that the NFL presented a weak case. Now, Ezekiel Elliott only had 1 case or 1 accuser against him, and that was considered within the league to be an exceptionally strong case. So why are 4 alleged victims considered a weak case? Is it the quantum of evidence? Is it their stories? Or does it have more to do with the strength of the disparate discipline defense or claim, which is centered on the absence of any discipline at all for Kraft, Snyder, and Jerry Jones, who've been accused of some similar alleged sexual misconduct? So why is it a weak case?
Well, first off, the NFL doesn't agree with the disparate discipline aspect of it. They said this is like, why are you even intermingling? You're coming and you're talking about our owners, and that has nothing to do with this. We're focused on this. Stop trying to intermingle other things that have no relevancy here. Obviously, the union would disagree with that.
And Paul Tagliabue, he set aside some discipline on that basis. Yeah.
And I mean, in terms of why it would, be those 4, I can't speak to that. I'll tell you what I would compare it to is when I was reading through some of the depositions, of the investigating officers in this case. At one point, the 10 criminal complaints that were brought, I was like, okay, in the back and forth between the lawyers, both under direct and then cross and the officers, it comes up that 2 of the 10 women are not represented by Tony Busby. And interestingly enough, it was Tony Busby who repeatedly read that into the record. These 2 aren't represented by us, correct? Kept asking the investigator this. And I was like, wow, this is like, why is he going out of his way to keep repeating that they're not? Well, eventually you get to the point, there were certain elements of their credibility that were damaged by, I think in front of a jury would have probably drawn consideration as, damaging aspects of their behavior following what they said was, hey, here's the criminal complaint on Monday, but then here's this thing that happened on Tuesday, Wednesday, Thursday, Friday, Saturday that looked a lot like the thing that happened on Monday, but we're saying none of those are criminal complaints. It's just the Monday thing. So so basically you could see Tony Busby looked at them and said, like, first off, it's like, I could poison the entire pool if I'm now representing, even two that look somewhat uncredible because of activity that they engaged in beyond this first. So I guess I would say, if you're the NFL, you're sitting there and you're potentially looking at the entire group and you're just saying, who gives us our best shot? Okay. And let's not, if it's 4, let's not make it 8, just so that we can bring 4 more to the table that don't have the kind of evidence that the initial 4 do. Okay. So if it's just that, I would think it's that standard of evidence that 4 gave you some sort of digital footprint, 4 gave you some sort of contemporaneous footprint. There was just some other surrounding factors that made those credible. And you don't necessarily want to intermingle this. And again, this is me playing lawyer here. I'm not a lawyer, but this is me sitting there going, I don't know if I want to intermingle that with 4 more that maybe I'm sitting there and going, okay, if I'm Sue Robinson, I'm saying, well, where are the text messages? Well, there are no text messages. Okay, well, where's the content? Who did they talk to? Did she tell her sister? No. Did you tell, her friend or this or that? Or there's no contemporaries, all we have is this. Maybe the NFL, again, that's just me guessing that the NFL sat there and said, look, we just want to stick with what we believe is the most presentable winning sort of argument here.
Yeah, but Charles, how do you do all of this and meet the preponderance of the evidence burden of proof without live witness testimony, which really comes back to the existential question: should the NFL be conducting parallel investigations based upon their own internal summaries without the live witnesses? When you have a conviction, when you have a criminal conviction from a court, that establishes the violation of the personal conduct policy. But how can the league, if I'm an attorney and I'm trying to prove something happened more probably than not, more likely than not, based upon actions that were taken, sexual misconduct directed at a victim, how do you fairly and accurately portray this without bringing the person into court to testify? So how can Sue Robinson determine whether something was more likely than not happened when there's no witness to testify? And secondly, there's no cross-examination of that witness to test the veracity of her statements under oath. How does she get there based on nothing more than the NFL's own spin or own narrative or summary of their internal review of their interviews?
I think it's a good question. I just can't answer it, And I also will say this too. I don't know whether or not some of the deposition testimony made its way into this or not. I certainly didn't have a huge problem getting my hands on it, and I would have to believe that Lisa Friel and the white shoe law firm that they use would not have a terribly difficult time getting their hands on either transcripts or video that they could have presented in this. I don't know. I agree with you. I think if you want to present the most full picture possible in front of Sue Robinson, you probably bring in who those 4 witnesses are. And that to me makes a lot of sense.
Well, you've been really generous with your time. I want you to get your rest because we're just gearing up. We're now in the phase of the case where there's no transparency. We don't know what's going on behind closed doors, but that's all about to change any day, where there's this public facing aspect to the case that's going to last for the rest of the summer, potentially. So do you have any sense of where this is going to end up? I know Mike Florio seemed to baseline it in the 2 to 8 game range. Do you get a sense whether that's sort of on the money? Do you expect something lower, higher?
I will say this: following the hearing and both sides kind of knowing, okay, this is how that 3 days went down. We know what was asked. We know what was presented. Everybody kind of knows what each side's bringing to the table. There was something that, inside Watson's camp, there began to be this talk of like, hey, if it's single digit games, if this is like 8 games, maybe that's something that we should just take and move forward. And, I think the Browns were, kind of privy to that too, like the thought process of like, and so I would just say, it's clear to me that there was a sense coming out of every side but the NFL that this was something that very much could end up being far less than a 1-year suspension. And that's why it did not surprise me when you started to hear, hey, maybe it's 8 games. But then as things went on and more individuals started to kind of speculate who had knowledge of how things unfolded, Then you hear, well, maybe it's 0, maybe it's 2, maybe it's like, we kind of made the joke before we kicked off here. It was 0 between, 0 and infinity. So
that's my personal bet. Between 0 and infinity.
Maybe we should do like the equivalent of an NCAA bracket pool just among all the writers and sports law analysts who are covering this. We could just turn it, combine my sports law and sports gambling worlds and just create a little tournament out of this.
So it's so at 8 games, would that be like the 1 seed? Like 8 games is the 1 seed.
Well, you got to put a year up there too. A year's got to be another big seed there.
Yeah, I'm going with 8 games. It's the middle ground at which both sides walk away. The NFL can offload accountability to Judge Robinson without bearing responsibility or facing criticism for going too light on him. And that brings Deshaun Watson back into the fold in 2022. So that's my prediction. I think that's the one potentially non-appealable suspension amount.
Right. What I've tried to, I guess, convey is just sort of think of the number that neither side is really that happy about. That's probably the right number.
Yeah.
And it seems to me that 8 to 10 range is the range that both sides would have a sour face about, but both sides would also go, okay, all right, it's not the greatest, it's not the worst, but this is probably where we are, and this is what we brought the arbitrator in to do. And I also think that inside the league office, there will be an element of some individuals, and I will say this too about the NFL's league office. I don't think everybody's all on the same page there either. Like, I don't think everybody agrees with, hey, it should be a year. There's different people with different opinions on this inside the league office. And frankly, I think that someone very likely in the league office would raise the specter of, okay, it's 8 games. That's not great. But do you want to sacrifice the arbitration system that we just set up by fighting 8 games? Like, that's the trade-off. Sure, go ahead, blow up the 8 games, but you also just blow up what looks like a pretty credible system. And actually, if we take the 8 games, looks even more credible coming out of this because we let the arbitrator do their job.
Personally, I think he already served the 8 games. Every game after that trade deadline, when he was non-movable because the specter of the exempt list hung over his head because Goodell didn't clear him. Every game beginning with that trade deadline afterwards is in effect a de facto suspension, and hopefully she'll address that in her ruling. And I hope the PA even argued it.
I think it's even further than that. I think when Roger Goodell came out and said, hey, when criminality was in doubt, when there was the question of criminality, that is when the commissioner's list, exempt list, would have come into play. To me, right then, I was like, well, he was already suspended for a year then. Like, so he basically, what Roger Goodell told the entire world without saying it was he suspended himself. He sat, we never had to make the decision, but the reality is, because criminality, the element of criminality was still in play, that's when the exempt list would have come into play. It just never had to come into play because Deshaun Watson and the Texans basically decided we're going to go ahead and clap our hands and walk away and not play this season. So I kind of was like, Roger just told you he would have been on the exempt list for a year. So technically you could look at that and say, well, Roger told us it would have been a year last year anyway. That was technically a year under what he said and how he described the exempt list. And then this suspension on top of it.
Wait a second. They owe him games, not the other way around.
If he had taken it upon himself, if he had not taken it upon himself to not play, I mean, technically they would owe him some games. Maybe he should have played last year, or at least attempted to get on the field.
As the case proceeds, as the case maybe goes to Goodell and maybe to federal court, Charles, we would love to have you back on, and always a pleasure to have you on our show.
Yeah, I'm actually in Las Vegas right now. It's like 110 degrees, and I got to tell you, I'm really psyched that this is all happening right as I begin my training camp tour. Of course, it couldn't have happened like a month ago and wrapped it up so we could start the season clean. So I'll come back anytime, guys. I appreciate it.
Thank you,
Charles. Thank you so much.
Thank you very much, Charles. It was a pleasure having you.
All right, thanks, guys.
So that was Charles Robinson. You can find him on Twitter at Charles Robinson. So I put up an informal poll, Dan, early in the week. I said, when do you expect Judge Robinson to render a decision on the Deshaun Watson case? This week, which is the week of July 18th, next week, the 25th, the week of August 1st or later. And 40% of people said next week, the week of July 25th. Dan, I will kick it over to you. Do you think that's right, or are we just going to be waiting into August on this one?
It's going to be July 25th. She's not going to screw with the NFL regular season by delaying this. I mean, she's already had the case under consideration for, close to 1 month already. I mean, it's been 3 weeks since the end of the hearing. She's a former federal judge who has, instead of law clerks working for her, she now has, lawyers, partners, associates at a law firm. I would expect that she understands the calendar that she's dealing with here, and that the NFL regular season begins in early September, the necessity for being able to leave some bandwidth for an appeal to Roger Goodell, as well as some period of time to file suit in federal court. I don't think she wants to see this, impeding the NFL season where, we're battling it out in federal court in week 6. I think she's going to decide on the week of July 25th for sure. Of course, edit this out if I'm wrong, but I'm going to go with July 25th, my father's birthday. And then we're going to begin the countdown, 3 days for either side to file an appeal. And we'll know from her decision whether it's the type of decision that one side or the other will appeal. Because if it's 8 games, I think both sides walk away. But if it's 0-2 or a full season, you can pretty much bet that one side will take an appeal depending upon the severity of the discipline. So this is exciting. These are the last few days around which there's all this intrigue, but no transparency. Any day now, a window is going to open up into what this hearing was about, what the evidence consisted of, and there will be a public facing aspect to this saga going forward, beginning with the week of July 25th. So the veil will be lifted any day.
Dan, I think we can wrap on that note for Dan, myself, the Conduct Detrimental family, everyone over at conductdetrimental.com. If you are a previous writer, be on the lookout for your emails. We're going to send out something this week. Obviously, it's the 1-year anniversary of our website. So we said big things were on the horizon. I think we're ready to get into that next phase. So be on the lookout for an email from us. And as always, if you would like to get involved in Conduct Detrimental in some way, shape, or form, just reach out. Okay, with that said, we will see you all next week on another episode of Conduct Detrimental.